My lord, I appear for the appellant's counsel in this matter. This is a challenge, my lord, to an interim order granted by the learned single judge, whereby, my lord, the proceedings before the National Company Law Tribunal have been completely put to a halt by saying that the order cannot be passed. Lord, may I just, your lordship may look at page 29, my lord. Page 29 is the interim order. We were on caveat and we opposed interim order, and thereafter this order was passed. My lord, the company called Arun Shelters was admitted, my lord, by the National Company Law Tribunal to corporate insolvency resolution.
Has the amount been deposited, Mr. Chinappa?
My lord, the first amount is deposited, I'm told. They have sent a demand draft for the 50% of
You
10
appear
crore.
for?
I appear for the bank, my lord, for Kotak Mahindra Bank, who is the appellant before your lordships.
What is your ground of challenge?
My lord, the ground of challenge, my lord, is that the proceedings before the NCLT could not have been stopped now, because the NCLT proceedings, my lord, is considering a resolution plan with respect to a company called Arun Shelters. And in the resolution plan, a sum of 46 crores, my lord, is to be paid to the bank towards settlement of the principal debtor's liability. And
what was under challenge? What was under challenge in the writ petition?
In the writ petition, or in the writ petition, if your lordships come to page 61, there was an order passed on 29th of June 2020. The writ petition is filed after 1.5 years. On 29 June 2020, my lord, a reconstitution of a committee of creditors was set aside by the National Company Law Tribunal. 1.5 years later, and when the NCLT is hearing the final hearing on the resolution plan,
that order is not appealable.
It is appealable. They did not file an appeal. They did not challenge that order at all. And may not come at the very end when the resolution plan is about to be accepted.
The petition is not maintained. You are not taking this ground. That is why we ask you.
No, my lord, I am. I have not, of course, filed my objections there. Why I am respectfully saying this is because...
No. The question is how the writ petition is maintainable.
It is not, my lord. My humble submission is
but that is why we ask you what is your ground of challenge. You did not say that, and it is not there in the report also.
Yes, sir. I of course, it is an alternate remedy argument. I'm sorry, my lord. I should have said that first.
Supreme Court says that the writ petition is not maintainable.
Yes, that is
against the order of NCLT.
Against the order of NCLT.
You are not taking that ground.
Pardon me, my lord. May I now take that ground, my lord? And therefore, my lord, what has now happened is the resolution plan was being heard on that very day, on 20th of December. The hearing, my lord, was happening before the NCLT on the same day. And, my lord, it has been stayed now. And owing to which, my lord, my 46 crores has not come.
But you amend your petition, appeal.
My lord, that ground is there.
Where is that?
My lord, the ground, my lord, is...
Either you took the objection or you have taken the ground appeal.
Of course, not. We pointed it out to the learned single judge, but I don't think there is a specific statement to that effect.
It is not always good that you take the ground of maintainability, but sometimes it is necessary also.
Yes, my lord. Can I humbly request, my lord, look at para 27, my lord?
7. Not in conformity provisions of IB.
And 28, my lord. 27 and 28.
Yes, it is there.
19.
You have to state. Whether they have paid the money.
My lord, the first 5 crores was deposited. The second 5 crores has not been deposited till today.
Can you serve them outside court?
I'm sorry, my lord.
Can you serve them outside court?
I can serve them, my lord. I can serve the
Because
learned
it is
counsel.
better that we decide the appeal itself.
Very well, my lord. I can
It
say
will
serve them.
stay- it will- Huh?
My lord, in any event, my lord, the final hearing
You have
on
not, you have not filed any IA.
I filed an IA for stay, my lord.
Hey, it is
IA for
there.
stay is there. IA 1 for stay. That, my lord, will find at page 157, 156, my lord.
What we feel is that if we stay the order of the learned single judge,
My lord.
then they would not be required to pay a further amount.
My lord, in any event, my lord, that is of course there, my lord, if that happens. But then the proceedings before NCLT is time bound, as your lordships know, my lord. 360 days, they must complete the CIRP process. Now that gets stalled completely by virtue of this order. And he's a guarantor, my lord. Your lordships may recollect last time I'd come before your lordships and your lordships had permitted a sale of his property.
Stay. Choice is yours.
I beg your pardon, my lord.
Choice is yours.
We
Lord,
could
your
serve the
lordship,
counsel for the petitioner and we could take it up on Monday instead.
Very well. I'll do that. I'll do that. Your lordship may have it on Monday. I'll serve it. I'll serve the council.
The other respondents,
My lord, the other respondents, of course, have not appeared before the learned single judge at that point in time. Therefore, your lordships may, my lord, dispense with notice for 2 and 3, my lord. 2, 3, and 4. Because the petitioner is Mr. Arun Kumar. He is a guarantor and the promoter of the company. And the company now, my lord, is of course under insolvency resolution.
4 is not required.
4 is
2
not
and-
required, my lord. 4 is not required.
2 and 3 is the same person.
2 and 3 is the same person.
You can serve them also.
Yes, my lord. I'll serve them by email then, my lord. I'll serve 2 and 3 by email because she's in Chennai.
In the meantime, you have to stay because proceedings are installed there.
When is the next date before the NCLT, Mr. Chinappa?
15th of February, my lord. I'm told it's 15th of February, but the hearing on the resolution plan has been completed. It is only reserved for orders, and the court held back its hand on that day because this order came.
So nothing will happen from today to the 15th.
Yes, ma'am. Nothing will happen till 15th. There's no question. Nothing will happen. That is true.
Even
Your
if we
lordship
say
may have it
the
on
order-
Monday, my lord. I'll serve them.
In case they do not appear or I think then you press for the interim release.
Yes, I'll do it. Very well.
Issue notice to the respondent 1, 2, 3. Learned counsel for the appellant undertakes to serve them outside court. The hand notice be issued to learned counsel for the appellant for service on respondents 1, 2, and 3. Considering the urgency in the matter, list on Monday.
I'm grateful.
Also permitted to serve the counsel for petition number, respond number 1 in the writ petition.
Yes, I'll also serve them.
He may serve the counsel who had appeared for the petitioner / present respondent in the writ petition.
Yes.
Also the email.
I'm grateful.
Email.